Hello, everyone, and welcome to this LexisNexis webinar on managing risks in legal drafting. We are thrilled to have so many of you with us this afternoon for this cross-border panel discussion featuring speakers from Hong Kong, Singapore, and Malaysia. A couple of quick housekeeping notes before we start. Please note that this webinar is being recorded and the recording will be made available on our corporate websites. Secondly, there will be time allocated at the end of the panel for audience questions, so please feel free to submit any questions you may have through the Q&A box, which you should be able to see at the bottom of your screen. Before we dive into what I'm sure will be a vibrant panel discussion, I'd like to invite my colleague Marcus to introduce you all to a brand new legal drafting solution available now in Hong Kong, Singapore, and Malaysia, Lexis Clause Intelligence. Over to you, Marcus.
Thank you for that, Roshni. Well, hello everyone, and welcome to the walkthrough of the core functionalities with Lexis Clause Intelligence. For this particular walkthrough, we'll be taking a look at Lexis Clause Intelligence Singapore, but there's no need to fret as the Hong Kong's platform, as you can see on the screen right now, and the Malaysia's platform are similar in terms of the feature that we'll be going through today. Now, Lexis Clause Intelligence is a tool to assist you in your legal drafting work by leveraging on advanced AI technology. This helps you specifically by analyzing your legal documents and surfaces relevant clauses, recommendations, allowing users to find the best practice wordings quickly and easily. First off, simply upload or drag your working template in the drop selection or in the drop section located in the Lexis Clause Intelligence homepage. Now, do note that the accepted format is in docx and that the uploaded files will not be saved in the platform or anywhere else online. This basically helps to maintain the confidentiality of your document. Now, upon uploading, you can see your uploaded template in the left-hand side of the panel on this analysis page. The navigation panel on its left allows you to easily track the clauses from your template on which the AI has recommendations on by simply hovering over them. And as you can see on the right-hand side, you have your clause recommendations. The AI recommendations made here are based on, among many others, on these following types of recommendations. The first one would be the different commercial position taken by the author of the said template. First off, you have the said clauses from the commercial position of a pro licensor. You also have another commercial position of a pro licensee. And last but not least, you would also have some similar clauses from a adjacent legal documents, as you can see right now. Other than that, you also have, depending on your subscription level, you also have recommendations from other jurisdictions that are available to you. As we can see right now on the screen, these are the recommendations from the UK jurisdiction. And last but not least, if you wish to view clauses beyond what the AI has recommended, a search feature is available for you where you can search within the Lexis Clause Intelligence platform. From here onwards, you can then proceed from here onwards, you can then proceed to go through this particular list of results to see which one of these recommendations would fit your existing legal document template. Now, those are some of the main key features of our Lexis Clause Intelligence product. This drafting tool is helping users streamline their drafting process, manage their risk, and improve efficiency through reducing repetitive manual research processes. Now, in this particular demonstration, I've only scratched the surface of the power of this particular product and what it can do for you. I would encourage any of you in the audience today who draft transactional legal documents as part of your work to reach out to us here at LexisNexis so that we can give you a more in-depth look at this LexisNexis Clause Intelligence product and what it can do for you. Last but not least, Lexis Clause Intelligence is also available now in Malaysia, Hong Kong, and Singapore. So again, do feel free to reach out to us. Thank you so much for joining us today, and we hope to see you in future demo sessions soon. Back to you.
Thank you for that quick showcase, Marcus. And to those of you who are just joining us, hello and welcome to this LexisNexis webinar on managing risks in legal drafting. Without further ado, I would like to introduce the moderator of today's panel discussion, Chin Yo. Do also feel free to participate in the conversation by asking any questions you may have through the Q&A box, and the panelists will endeavor to answer as many as possible at the end of the panel. Over to you, Chin.
Thank you, Roshni. Good afternoon, everyone. Thank you for dialing into this LexisNexis webinar, Managing Risks in Legal Drafting. My name is Chin Yo. I'm a partner of Ashurst in Hong Kong. I'll be your moderator for today. It's with great pleasure that I introduce our esteemed panelists for today, who are based in Hong Kong, Singapore, and Malaysia. Johnson Ong is Group Legal Manager at iBerhad, a Malaysian-listed property development and investment group. He has a broad in-house practice which covers litigation, regulatory and compliance in commercial matters. In 2021, he was named Young Lawyer of the Year in-house at the Asian Legal Business Malaysia Law Awards. Machuana Chu is a partner at Deakins Hong Kong. She has extensive experience in cross-border M&A in Greater China, and her practice has a particular focus on technology and data protection. She is recognized as a leading lawyer in her field in multiple legal directories. Alistair Tan is a director of Drew & Napier in Singapore. His experience and practice focuses on complex corporate commercial and insurance-related disputes. He also has a very active arbitration practice. As for myself, I'm a partner of Ashurst in Hong Kong, and my practice focuses on M&A, private equity, corporate and commercial matters throughout the Asian region. I also advise Asia-based clients on outbound investments into Europe and Australia. The topic for today's webinar is managing risks in legal drafting. Our panelists have kindly agreed to share their practical insights on how best to manage legal drafting risks. Our focus will be on sharing real-life examples from in-house and private practice so that you can benefit in your own practices from the experience and reflections of our panelists. I'd just like to start off the panel discussion by asking Johnson a very topical question. As an in-house lawyer, you would often come across commercial contracts containing force majeure or material adverse change clauses, something which is quite typical at the moment with the pandemic and the changes in markets. What are some of the pitfalls that you've seen in the way these clauses are drafted? And what is your advice on how to improve these clauses?
Hi, Chin. Thank you so much for the kind introduction. Before jumping into the question, I just want to take this opportunity to thank Lexis for organizing this event, and also to all the participants for taking our time of attending this webinar as well. I'm very honored for the opportunity of sharing some of my thoughts here. So back to the questions. Focusing on force majeure clause and the material adverse change clause, I believe that most lawyers would agree that the most common pitfall that lawyers would normally encounter would be boilerplate clause that is drafted very loosely and very broadly. Let's just take a force majeure clause as an example. So for the sake of everyone to understand what a force majeure is, I will just provide a very brief context. So when a party enters into a contract with another party, both are under the legal expectations of performing according to the terms of the contract, and a failure to perform will be considered as a breach of contract. But since we live in an imperfect world, there will be supervening events that are beyond the control of any party. And this kind of events is what we call as a force majeure. And usually, generally, when a force majeure event happens, a boilerplate clause would typically say that the affected party will be excused from the performance, and they will not be liable for the non-performance. And the lawyers will usually draft this clause as a force majeure clause in a contract. But a badly drafted force majeure clause will be abused by a mischief party. In other words, if a force majeure clause is not drafted well enough, a mischief party may abuse it by using it as a get out of jail card of not performing and get out of the contract without being liable for that. So today I'll be sharing mainly on 2 points on how to tighten a force majeure clause. And then I believe that this topic will be particularly important, especially these 2 years of pandemic, because I believe that most in-house counsels and lawyers will be encountered on parties trying to exercise a force majeure clause. So the first point is to specify and to tighten the definition of a force majeure event. Instead of relying on a boilerplate clause, we should normally broadly define a force majeure event as any unforeseeable event that is beyond the control of any party, which would practically mean anything and everything under the sky. I think that parties should always aim to limit the scope of force majeure event to a specific list of finite events, such as maybe pandemic, maybe naturally occurring disaster like earthquake, war, or act of terrorism. It would be even better if parties could actually expressly exclude certain events from being treated as a force majeure event. For example, the party can make it very clear by saying that financial hardship, changes in market conditions, or even things like changes in material costs will not be triggered, will not be treated as a force majeure event. This is very effective. The reason being so is that this could prevent a mischief party from just treating any random event as a force majeure event for not performing and getting out from a contract without any liability. But in the event where a force majeure event actually occurred, as I mentioned previously, a boilerplate clause would automatically consider that, will automatically state that the affected party will be excused from performance and there will not be any liability and a contract will usually be terminated. But in a real life example, this is hardly effective or hardly helpful for any organizations, because when a parties enter into a contract, the clause should be drafted in a solution-centric manner. So instead of relying on a boilerplate clause of just immediately excusing the party from performance, what a party could consider is to actually first impose a mitigation duty on the affected party by maybe just imposing a temporary relief as to the performance of the party, and then impose a specific time frame for the affected party to mitigate and to find a solution in resolving the effect as to the force majeure event, such as maybe proposing or finding solution to maybe carry out part performance of the contract, and make it very clear that if the affected party fails to carry out any mitigation duty, it will be considered as a breach of contract. And this point, from what we realize, is that it is particularly effective because this could prevent an affected party from immediately walking out from a contract the moment a force majeure event has occurred. And for an in-house lawyer, this will be essential for the organization, because a lot of time when we enter into a contract, most of the time we are taking a very long-term perspective. So instead of allowing a mischief party from simply triggering a force majeure event or just walking out from the contract just because a force majeure event has occurred, if the parties could specifically limit down what is the scope of a force majeure event or even an MSC clause, this could really help the organization to move forward by finding a mutually beneficial solution for both parties. Yeah, back to you, Chin.
Great, thank you very much, Johnson. That was very a lot of practical insight there. I guess the moral of the story is, force majeure clauses come in a variety of forms, and applying a boilerplate each time doesn't necessarily work for the situation. So perhaps a kind of tool like LexisNexis Clause Intelligence will give you some insight into what is the best drafting for force majeure type clauses or material adverse change. So I just want to have a discussion with Maciuana, and this is looking at kind of drafting mechanics. So for clauses in contracts where a party to the contract may be entitled to exercise a right, for example, the right to terminate the contract or to exercise an option to do something under the contract, it's often important to draft the clause in a manner that provides the proper mechanics. Could you perhaps share some insight and examples of how this should work in practice?
Sure, definitely. Thank you, Chin, for asking the question. Hi, everyone. This is Maciuana Chu from Deacons Hong Kong. Very pleased to be able to speak to you today. I'm very pleased to see there's so many people joining this webinar. Back to the question, by way of background, I'm a corporate M&A lawyer. So you can imagine my daily life is drafting, more drafting, reviewing drafting, and amending drafting. So very happy to share with you my experience and observations as to what are the major risks that can happen in terms of drafting a document. So as Chin has just mentioned, in an agreement, in a template agreement, is often that the agreement defines the rights and obligations of the parties, and it's also common that it comes within mechanism in terms of exercising certain rights in the agreement. I think the beauty is that apparently it's very useful because it provides the practical steps as to what to follow and what to happen, but also it's also equally dangerous if we use it as a cookie cutter. If we take out a template and just plug it in, then it can cause problems sometimes. So I think as lawyers, we really need to go through the mechanism template to see whether it is applicable, first thing, to your situation, and also whether it is practicable or practical. So as an example, in case of an option, for example, if we are drafting a share option agreement, it's really important to understand the basics as to what it is. I think the easiest way to ask ourselves is what, why, when, and how, right? Address all these really precisely. I would see a share option agreement a high-risk agreement, a high-risk document, because if the provisions are not drafted precisely, one day it will come back to you quite soon usually. So yeah, so I usually will pay really much attention to the draft and make sure that everything is crystal clear. In terms of what is the subject matter, who can exercise the option, when, how, what is the price? Because I think the tricky bit is the determination of the price. Whether it is a fixed price or more often it refers to a formula. And very often there are certain finance and accounting terms used, for example, like book value, market value, or reference to the company's EBITDA, profits, or even more complicated like operating cash, excess cash. All these are really, it require financial expertise to confirm what is the meaning when we are calculating the consideration of a share option. So I think that the takeaway is we should ask the clients, the finance department, finance director, or the external financial advisor to really confirm what does that mean precisely. It's easy to assume that is a definite or certain meaning attached to that kind of financial terms. But there are also cases that actually is also subject to debate. So I think precision is really important in terms of setting out what are the meaning in terms of calculating the consideration of the share, of the share option. So this is one thing. Another example to share is I've got an ex-colleague, very experienced lawyer. He participated in the drafting of a document, and after a number of years, he was asked to testify before the court to testify what was the intention when the parties agreed that the book value of certain assets, what was the intention behind, because the drafting was not that clear and apparent. Their argument as to what does that mean. So and then as lawyers, it would be put in a fairly difficult position because it's a number of years ago, right? Unless you have really detailed telephone notes or meeting notes to say what was the intention behind, you may not remember that. And secondly, the intention may not be that clear. Sometimes clients just say, okay, book value of certain thing. It may not indicate what is the reference time in determining that value. So yeah, it can cause a lot of stress for the lawyers involved, potentially negligence claim. So I think this is really important to note. And another thing is in relation to drafting, for share option for Hong Kong, in terms of transfer of shares, we typically would suggest to include all the steps required to transfer the shares. So like preparation of the instrument of transfer, contract note, and in Hong Kong, we also need to submit the financial statements of the Hong Kong companies to stamping. And this may cost time, and also if a party doesn't cooperate, then it may drag and cause delays. I think all these with a really nicely and precisely set out mechanism, it would really help.
Great, thanks very much, Machuan. I think that actually the way you summarize it, what, who, when, how clauses need to include all of those details to have the proper mechanics is very, very helpful actually. I just want to turn to Alistair now. As a litigator, you've probably seen cases where the outcome of a case has depended on very fine aspects of legal drafting, even down to punctuation. And there's been a case in the US where even the use of an Oxford comma would have changed the outcome of multi-million-dollar litigation. What's your experience of how the finer aspects of drafting, such as punctuation, can be of critical importance to a dispute?
Thanks, Chin. Again, I suppose thank you everybody for taking the time to attend our webinar, and thank you Lexis for organizing this. I think to your question, I suppose hindsight is always 20/20. Punctuations are important. At the end of the day, the issue is what did the parties intend when they when a particular clause was drafted. And of course, you go back to first principles, you always look at how the clause is worded and what meaning would you derive from that. So to answer your question short, yes, it is extremely important. And there are a lot of cases which have turned on the issue of punctuation when the courts are asked to determine the intention of parties. I'll give you an example of a recent case which stands out. It stands out because it arises or it's related to COVID-19, specifically an insurance coverage dispute on whether the insurer was liable for losses under a policy because of a mandated closure of a hotel. I mean, as many of us would have encountered or be aware of, when the pandemic first started in April 2020, governments across the world were issuing blanket closure orders. So malls had to be closed, hotels had to be closed to contain the pandemic, the spread of COVID-19. And the hotel in question had insurance coverage which covered business interruption losses resulting from a closure order as a result of many things, but two in particularly important is that the first one was an outbreak of an infectious disease, which obviously included COVID-19, or defects in sanitary arrangements at the premises, so at the hotel. So basically, liability under the policy would be triggered if a closure order was issued as a result of the outbreak of COVID-19 or plumbing defects at the premises. So because of a missing Oxford comma, the question, or rather we took the point, the question was whether they had to be a COVID-19 case at the premises. So in other words, whether the phrase at the premises applied to both COVID-19 and plumbing defects, or it only applied to plumbing defect section. And because the comma was missing, a more natural and reasonable interpretation was that naturally it only applied to plumbing defects because, of course, I mean, plumbing defects had to happen in the hotel for the hotel to be closed. And that was not the case with COVID-19. And in legal submissions, I mean, usually it's a lot of cases, but here is a lot of English grammar. So, and particularly, I mean, what I learned was what we call the last antecedent rule. I won't go into in detail what it means, but effectively, whether at the premises applies to both instances or one instance. And the funny thing here, and I suppose it's important to take note, is something is not broken, don't change it, was that the policy for the preceding year, this issue would not have arisen had the wording been maintained. Because how it was done previously was that, as with many clauses or when certain conditions need to be satisfied in contracts, you list it down, 1, 2, 3, 4, 5, 6, right? So in the previous policy, how it's worded is that, look, closure as a result of 1, infectious disease at the premises, number 2, plumbing defects at the premises. So each of these conditions clearly required the event to happen at the premises. But this was not the case with the updated wording. We ultimately won the case, meaning that the insurers were found liable on a different point. The appeal is pending. So I suppose back to your initial point about best practices. I suppose the key lesson here is that, look, if you are going to set out conditions or back to Marchuana's point and so on the mechanics, you need to listen up, think it through, list it up clearly on how things are to work, and of course, break it down to sub-clauses if necessary. Yeah, I think that's my perspective at least.
Thank you very much, Alistair. I think something I need to brush up on my English grammar. But I mean, even the use of an Oxford comma can be very, very helpful, even if we don't use it in daily writing, but in legal drafting, it could really make a difference to the meaning of a clause. There's one topic I would like to share some insight on. I think many of the people dialing in are in-house counsels, and I'm sure you often have the experience of a tension between what business team wants and what you as a lawyer want to do to protect legal risk. And usually business team often wants things to be short and sweet. They may have a particular preference for a particular kind of wording, which sounds friendly, doesn't cause any problems. But oftentimes that kind of situation may create ambiguity and documents and clauses which might not be legally effective. And the issue here is that commercial kind of wording that business teams may want to include in documents may not be sufficiently clear. They may not be the mechanics, as Machuana talked about, or precise drafting, as Alistair talked about, for it to be clear legal drafting. And the good drafting needs to really set out rights and obligations of the parties, who, what, when, why, how, as Machuana discussed. When I've had some experience working in-house, and there's always a preference, as I mentioned before, for documents to be shorter. Sometimes you can try and work with formatting to do that, but oftentimes you need to really reduce content. And it's really a balance here between understanding commercially what's important, understanding what are the likely risks that may arise in the business situation, and addressing those important things, not necessarily taking all the boilerplate clauses, which Johnson talked about, and putting all of them in, only those really focused on the current situation. That's just something I wanted to share in terms of legal drafting. Now, coming back to Machuana, another area of legal drafting risk is time pressure. So as we are all very, very busy lawyers working on many different matters, whether in-house or private practice, we face a lot of time pressure to get things done. And working under intense time pressure can increase the risk of errors occurring. Do you have any examples of this to share, and thoughts about how to manage this time pressure risk?
Indeed. 2 points I would like to raise. One is about version control. Because we go through many rounds of negotiation, review, and updating before a document can be finalized. Because I think in private practices, it's usually easier because we already have version control software, system, protocol to help us compare documents, and our associates are experienced in consolidating comments from different parties and turnaround. So I think it's important to make sure that we are always working on the latest draft, and that the comments that we want them to be put in, to be incorporated, are there and not dropped off at any time. And I appreciate in private practice, it might be a little bit more difficult. This is really something that is important as well, to make sure that we are working on the correct draft, and that the correct draft is being signed, because I think that is pretty fundamental. Another observation I would like to share is because we are working under extreme time pressure, and it's not uncommon that the schedules are always being left to the last minute. So we negotiate and we finalize the drafting, beautifully crafted. The schedules are still empty, and very often at last minute we collect the schedule, and it's not untypical that the schedules are often inputs from the business department, from the business from line. So they give us the schedule. Sometimes we will just plug in and then get the signatures and things done. That can be quite dangerous, because I think as lawyers we also need to make sure that what's in the schedule is also prescriptive enough, precise enough to give meaning to the overall agreement, because the legal implication in the schedule is as important as a clause in the body of the agreement. So I think this is something to note, that if the business give us some drafting or bullet points that we do not understand, we need to clarify and really need to make sure that the schedule ties in with the contents of the agreement themselves.
Great, that's very helpful, Machuana. Now I just want to kind of shift the discussion a bit more towards disputes. And a question for Johnson, as an in-house lawyer whose practice focuses a lot on disputes and litigation. I think you would have a real appreciation for a well-drafted dispute resolution clause in a contract. And on the contrary, I'm sure you've come across quite a few badly drafted dispute resolution clauses, which have caused problems. Be grateful if you can share your insight and tips in this area.
Hi, Chin. Thank you so much for the question. I'll be sharing from a very practical approach to what considered as a badly drafted dispute resolution clause. It's true that I have came across a fair amount of a badly drafted dispute resolution clause, but in my opinion, and from what in-house experience they have observed, a lot of time, a perfectly drafted, in fact, a watertight dispute resolution clause, but it's drafted in a way that is disproportionate to the nature of the deal, to the nature of the transaction. In fact, it's far more damaging than a perfectly drafted, a well-drafted dispute resolution clause. In fact, we have quite a fair bit of experience of seeing a perfectly drafted, a watertight dispute resolution clause, in fact, handicap an organization to their right for dispute resolution. Just for illustration purposes, I would just be maybe just sharing a very typical, a very standard boilerplate dispute resolution clause. Just for context purposes, it may be read something that both parties mutually agreed that in the event of any dispute arising of the agreement, the dispute shall be exclusively referred to be finally settled by way of arbitration in SIAC according to SIAC rule. And then the arbitration shall be conducted in English. The arbitration tribunal shall be of 3 arbitrators and from different jurisdictions. For the face value, if this is drafted perfectly, there's no consent to this dispute resolution clause. But if the lawyer is just copy-pasting this boilerplate clause to a different context, to a simple share and purchase agreement of a share of a contractual value of only 3,000 USD, this will be a disaster to an organization. And as an in-house lawyer, I have encountered quite a fair bit of this kind of scenario. The reason is because no matter how perfectly drafted the dispute resolution clause is, it is hardly justifiable for that particular dispute matter to be referred to arbitrations in view of the cost. And if the organizations realize how expensive arbitration is, and they want to resolve the matter by way of litigation in the local court, lawyers will find it extremely difficult to actually go by way of litigation because of how perfectly drafted the clause is, making it very clear that SIAC shall have exclusive jurisdiction. And this scenario will often handicap an organization, and this makes a perfectly drafted clause to become a total disaster to an organization. So, but there isn't any fast and hard rule as to how to draft a good dispute resolution clause. So I'll be sharing maybe on 3 simple guard rules to consider when one party is going to draft a dispute resolution clause that is proportionate to the nature of the deal. The first one is definitely has to do with the contractual value of a transaction. If the deal concerns a very high value transaction, it may not be always true that a matter should always be referred to arbitration because certain considerations such as enforceability of the award, the location of the assets should be taken into account. But if the deal concerns a very low amount of value, it is more often true than not that this matter is more advisable to be referred to litigation in local court, unless there are reasons, specific reasons for it. Otherwise, it's hardly justifiable for a very small value dispute to be referred to arbitrations, because unlike judges for litigations, arbitrators are rather expensive and you have to pay arbitrators for the services. So the second point has to do with the complexity of the matter. So if the deal involves highly complex matter that's involved maybe technical issues such as nanotechnology, for this kind of matter, maybe it's more advisable to refer a matter, this kind of dispute, to arbitrations where the arbitrator may be an expert from that particular field, instead of referring to a judge where the judge may have zero knowledge about nanotechnology at all. And the third consideration point will be in relation to the neutrality. This is particularly important where both parties are from different jurisdictions. For example, maybe one from Hong Kong and the other one from Malaysia. So to prevent any perceived homeland or home field advantage or any potential bias, it may be more advisable for the matter to be referred to arbitration from a neutral country for arbitration, whereas the parties could also specify that the arbitrator should come from a different jurisdiction. As I mentioned earlier, there isn't a fast and hard rule as to how to draft a perfect dispute resolution clause, but what is more important is the drafting of the clause itself has to be proportionate to the nature of the deal. Otherwise, even a perfectly watertight dispute resolution clause could also handicap an organization if one is disproportionate. And this is what in-house lawyer frequently encountered whenever issue arises. Then arise that, oh, I can't go for arbitration because the cost is just not justifiable. So I think that this sharing will be helpful for in-house lawyer. Back to you, Chin. Thank you.
Great, thanks, Johnson. I think that is a very practical view from in-house, in particular in relation to costs. From the private practice perspective, Alistair, as a private practice litigator, you're often involved advising clients on how to navigate and properly exercise rights under dispute clauses. What are some of the problematic areas that can arise here? And do you come across instances where arbitration and court claims may run concurrently?
Yes, that's a good question, Chin. I think firstly, I mean, dispute resolution clauses, I mean, are usually one of the last things you consider when you negotiate a deal. Because I mean, it's like marriage, right? You don't go in thinking about the end or when something's going to happen. You go in thinking, look, let's get the deal done. So I think often dispute resolution clauses are one of the last thing, something that business will not think is important in any event. And of course, it's a choice between going to court or going to arbitration. And I think I echo Johnson's view on, look, it's about proportionality, which forum works better for a particular transaction. Arbitration may be the sexy thing, but that's not always the best thing for a particular deal. And I think from a private practice perspective, there are usually three common scenarios or problems. The first is where they are unenforceable multi-tiered dispute resolution clauses. I'll go on to explain a bit more of these in a bit. The second ones are what we call pathological arbitration clauses. And the third one, it's inconsistent dispute resolution clauses. So a situation where the same contract provides for disputes to go to court, and another section of the contract, it provides for disputes to go for arbitration, for example. So on the first one, multi-tiered dispute resolution clauses. These are essentially clauses which impose certain preconditions, for example, for mediation or good faith discussions before the party can pull the trigger and commence legal proceedings. And a common issue here is when the preconditions are unclear or where there is no certainty as to when these preconditions would have been met. For example, often the clause simply states, parties are to engage in good faith discussions before commencing proceedings or legal proceedings, for example. Then the question is when there is a dispute that actually occurs, so what are good faith discussions? Is it a function of duration? Is it a function of seniority? How long must these discussions take place? Can we say we discussed this for 5 minutes? We knew that a settlement was not possible. I can now proceed to pull the trigger and sue. And the other thing, and it often happens, it's what happens if the other party or the opposing parties is difficult, or they delay the matter by postponing the meeting. So we can't meet here, we can't meet then, our director is away, we need to get approval to meet and things like that. So that drags on the dispute. And one other issue that arises from that is that if you proceed to commence proceedings where there is certain uncertainty as to whether or not the preconditions have been met, this usually results in a jurisdictional challenge on the basis that, look, the tribunal has no jurisdiction to determine. So in an arbitration scenario, the tribunal has no jurisdiction to hear the dispute because the condition precedent to sue has not been met, has not been achieved. Or in a court scenario, they will tell the court, look, proceedings should be stayed until parties have been able to, until this condition has been satisfied, for example. I mean, even if the objections are dismissed, it often results in a lengthy delay and significant cost because there's a huge fight over things like these. So, I mean, my 2 cents worth, if you're minded to incorporate multi-tiered clauses in a dispute resolution clause, I think I'll go back to what Machiwana said. To think about the mechanics. So how, when, where, and things like that. So good practice is always usually you state clearly disputes should be referred to discussion between senior management. The key thing is that to set a time period, look, when would the condition be met? So for example, if no settlement is achieved within 20 days, you can then go to the next step. So it could be formal mediation, or you then commence proceedings. My personal preference, I'm not a big fan of multi-tiered clauses, but it has sometimes been useful because it allows parties to initiate discussions without losing face. So because when a dispute comes to us and you say, look, do you want to consider settlement discussions? The question we frequently get from the client is, do you think my case is weak? Why do I need to initiate discussions? I have a good case. You've told me I have a good case. So why do I need to lose face by saying, hey, let's come to the table and talk? Why can't I just sue? So these clauses often help remove that stigma. One other point I would add here is that Singapore recently amended its rules of court. This is the equivalent to the CPR in the UK. And parties are now under a duty to consider amicable resolution of the dispute before commencement and during the proceedings. So what that effectively means is that if you're going to sue, you will have to at least make some form of offer for ADR, or at least that you want to settle the dispute. So it's with a view of reducing the workload, reducing disputes, and only ensuring that real disputes go to court, for example, those that really cannot be resolved. I'm conscious of time, so I'm just going to move on a bit quickly here. And the next one are pathological arbitration clauses. So what this means is that these are arbitration clauses which contain inherent defects. So it's clear that parties want to go for arbitration, but something not workable in the clause. And a frequent occurrence is that the clause refers to a non-existent arbitral institution to administer the arbitration. And one example which I encountered recently is that it was an arbitration clause in Singapore, but it stated that the arbitration to be administered by the Singapore Chamber of Commerce. Couple of problems there. First, there is no such organization in Singapore. It's either the Singapore International Chamber of Commerce or the Singapore Chamber of Commerce and Industry. And the more importantly, neither of these institutions administer arbitration. So as far as possible, and from a Singapore perspective, the courts will always give effect to an intention to arbitrate. And it often involves the court inferring the intention on the part of parties that, okay, what you really meant was that you wanted disputes to be referred to arbitration in the SISC, for example. The last one is inconsistent dispute resolution mechanisms. This usually happens when parties try to incorporate different agreements into and to be consolidated into a single agreement. So one part of the agreement will say, yeah, disputes go to arbitration. Certain addendums will then say disputes go to litigation, for example, court litigation. So these again can cause problems with jurisdictional challenge and again delay the conclusion of a dispute. It's not an issue to want certain disputes to be referred to arbitration or certain disputes to go to litigation. For example, we've seen clauses that say dispute on liability will go to court, dispute on quantum will go to arbitration. That's perfectly workable. So again, I think business and legal often have to have discussions as to the pros and cons of doing that. Again, the Singapore adopts a pragmatic approach. As long as there's a clear intention that parties want to go for arbitration, the court will uphold that and it will prevail only over any other clause. Back to you, Chin.
Great, thanks very much, Alistair. I think that's a very good discussion about practical proportionality of dispute resolution clauses, and also how they're best drafted in terms of mechanics. Before we go to Q&A, I just want to mention one last topic, and that is about how when we're negotiating agreements, sometimes in order to get the deal done or document agreed, we kind of agree compromise positions. And let's say there's a clause where one party doesn't want to agree to be subject to an obligation, so we just water it down to reasonable endeavors or commercially reasonable endeavors or all commercial endeavors. Or as Alistair mentioned, if there is a certain event occurring, parties will discuss in good faith. The problem with these kind of middle ground type wording is that it's often the case it's not clear what that means. And that can create kind of soft spots in the contract, which may lead to disputes in the future. So I think the issue here is that either we want to get transactions done, so we end up using these compromise positions, and at the time that we're negotiating the document, we don't think there's going to be a breach scenario, so people are okay with it. But once there is a breach scenario, then these are exactly what the litigation teams look at to try to figure out, okay, is there a obligation here that's hard and fast that we can enforce? And this has led to, in my experience, quite a lot of problems in long-term agreements like joint ventures. Had a situation recently where a party has done something which has not been contemplated in the joint venture agreement, and technically it is not a breach, but effectively it's something which has frustrated the purpose of the joint venture, and the parties have had now in discussions about how to wind it up. So I think the answer here is when you do look at putting this kind of compromise wording in, or you kind of kick the can down the road by saying, well, if something happens, then the parties will discuss in good faith. You need to think about, is it realistic that this is going to happen? How is it going to play out in a dispute type situation? Now, I just want to go to questions. We've had quite a few questions that have been submitted by the audience. Thank you very much. I don't think we have time to address all of them, but in the time remaining, we can address a few of them. There's a question directly from Machuana. Hi, Machuana. Appreciate if you could share some insights on how to prevent defective execution of an agreement, or how to ensure due execution. Thanks.
Sure. I think we all appreciate it's important to make sure that, after all the lengthy negotiation, the document is properly executed, and the consequence of defective execution apparently is very serious. To dissect this question, I think I would address it from two aspects. One aspect is, in accordance with the law, the applicable law, what are the requirements of the execution? For example, like in Hong Kong law, execution of an agreement or execution of a document as a deed, there are different requirements that must be complied with. So I think in terms of formality, we need to make sure that the formality are followed so that it's not defective. Another aspect of execution is in relation to authority, because we want to make sure that the person who signs on behalf of a party, they has the required authority. And we need to understand what kind of evidence we're required to check the authority. For example, we need to check the Articles of Association to see if there's any prescribed requirements. And also, shall we ask for board resolution or shareholders resolution? I think and another angle about execution is it would become more complex when we are dealing with the cross-border agreement, when there are like 10 parties are involved and they are different countries in the world. We don't know whether they have a seal. We don't know whether, for example, like China, a legal representative can sign without the authorities of a board resolution. Things like that. Things are really specific to that country in relation to execution. So I think all of us would like to kind of equip ourselves or have some sort of protocol in terms of confirming the legal requirement in terms of of formality, and also what are the steps that we need to take in order to confirm that the authority is duly given by that party.
Yeah, I mean, I think experience of running deals is that we kind of negotiate down to the wire, and checking all this deal execution is a very, very final thing, and we don't have a lot of time for it. So it kind of joins that time pressure question as well. But I always tell people in my team, if we don't have deal execution, we have a lot of problems, and we actually have to focus on deal execution. Otherwise, these clauses may not mean anything at all. So it's a very important part of drafting to get correct. Just moving on to some other questions. There's been a couple of questions which are similar, and they are kind of about the word reasonable. So what's your opinion? This is a question to everyone. What's your opinion on the wording reasonable opinion, commercially viable, or just reasonable in general? And how can we make it more clear? And potentially, if we want to make it more subjective, if it's reasonable opinion, for example, how can we make it subjective to a particular party in its circumstances? So I might ask the litigation-focused guys, Johnson and Alistair, this question actually, because I'm sure you've come across this either in-house or in private practice.
Thanks, Chin. I mean, as litigators, we love this phrase reasonable. I think as lawyers in general. But I mean, the truth is, aside from setting out exactly the conditions that need to be met, I think reasonable is basically the best phrase to use, because you can't really contemplate everything and anything. And I mean, I don't think there's a short answer to this. I'm a fan of the term reasonable, especially, of course, if you're negotiating on one side, you say reasonable as determined by my clients, and the other side is hell no, it'd be reasonable determined by me. But I think when you go back to reasonableness, it's always a safe bet, because at the end of the day, you're really looking at reasonableness vis-a-vis the two parties who enter into the transaction. So if they're big organizations, for example, what would be reasonable? And then you have evidence as to, look, as an independent expert, for example, what you consider to be standard practice in the industry. I think more often than not, parties to the dispute or parties to the transactions have some inclination as to what they will consider reasonable. The issue is really, look, when there's a contentious dispute at hand, do we want to give in? Do we want to accept their definition at the end of the day? So, I mean, I don't know if that's answered the question, but that's at least my 2 cents worth.
Great. Maybe I'll just actually move on to a different question that's been submitted, and this is actually about part of it. Most agreements have a notice provision, and the question is, what are problems with drafting? Potential problems in drafting notice provisions, and what if those notice provisions are not complied with? And maybe I'll ask Johnson that actually.
Hi, Chin. Thank you so much for the question. I think they'll just use like a construction agreement as example. So basically, for construction agreement, a notice provision is extremely common, particularly when you want to make any warranty claim or whether there's any disputes. So basically, I think that it has to do with different jurisdictions as to how will the court interpret the importance of the notice provisions. But the best advice is to always err on the side of caution, is that the moment a notice clause, assuming that if you want to make any particular warranty claim, you are supposed to issue a notice to the other side within 21 days. And assuming if a party only issued a notice after 21 days, what will happen? Does it mean that he waived the right? So as an in-house, usually what we do is that whenever we encounter this kind of clause, the first thing that we want to highlight is to ensure the business side, the business team, are you sure that you are able to comply with the time requirement, 21 days? If the answer is yes, you make sure that this is in your calendar, because we do not want you exceeding the 21 days, then only you're fighting litigation lawyer, litigation team to resolve the matter, because the court may actually interpret this kind of notice provision very strictly. And so the best advice is the moment it's being drafted, first of all, make sure that this clause could be complied, could be fully complied. Second thing is, if this could be fully complied, have to always ensure the business team, whenever an issue arises, always refer back to what is the time period or what is the notice provision. For example, they say that you have to issue the notice by way of email, by way of prepaid letter, whatever it is, just strictly comply to prevent any unnecessary disputes. Yeah, there will be the advice from my side.
Okay, that's a good insight. There's a very interesting question that's been submitted actually, and it's not something I've ever thought about. And it's about from an anonymous attendee. And it's where counterparties highlight words in yellow in an agreement, and it's executed with highlighted wording. Would that affect the interpretation? And I also have a similar question, which is, do you think previous drafts of an agreement and what has ultimately been put forward but not included in the final through that negotiation process may affect the interpretation of the final document? I might ask Machuana that question.
Okay. First of all, okay, about highlighting in yellow, I tend to think that it shouldn't affect the interpretation too much. Before we understand who highlighted that, it might be an associate or a trainee reminding herself that something that has yet to be done, or unless at a later stage you know that the reason the parties why they are emphasizing certain provision that has a specific meaning. Otherwise, I tend to think that it shouldn't affect the ultimate interpretation. On the second question is about
previous drafts and whether what's included.
Okay, I think it can be circumstantial evidence in terms of interpreting or at least illustrating what can be the intention behind when the parties agree to something ultimately. So I think we tend to keep all the versions and all the notes of the party decide to modify the position in a provision. But of course, it also depends on the boilerplate of that particular agreement. If it says that it supersedes all previous discussion or anything that has been signed and discussed, then that boilerplate provision will need to be respected as well.
Yeah, no, I think it's a very interesting question actually, because obviously you have a whole agreement, entire agreement clause, but when interpreting the intention of the parties, you can look at things outside the agreement, obviously, and the obvious thing is what they've discussed to get up to that agreement, which is reflected in the drafting. So you do need to be quite careful about making sure you keep previous drafts and really what does that mean in terms of the interpretation of the final draft. Now, we just have 1 minute.
Just to add to that, I think one other point, aside from the entire agreement clause, which often is relevant, the other thing to consider there is also in most jurisdictions, like common law jurisdictions, we have what we call the parole evidence rule in the Evidence Act. So that's the case in Malaysia, that's the case in Singapore, although Singapore adopts a more liberal position now. And what that basically precludes parties from doing is to introduce evidence pre and post contract when you construe the agreement. So that may be an issue as well, but of course it would be jurisdiction specific. But at the end of the day, I agree with you and Machuana that it's certainly relevant to ascertain the intention of parties by looking at how the negotiations, I suppose, transpired.
Great. We've run out of time, so I just want to wrap up by thanking everyone who's dialed into this webinar. We hope that you found today's discussion helpful in your own individual legal practices. And I'd like to also thank all of our panelists for sharing their experiences and practical insight. So let me hand back to Roshni from LexisNexis to wrap up.
Thank you, Chin. On behalf of LexisNexis, I would like to thank our panelists, Johnson, Machuana, and Alistair, and our moderator, Chin, for participating in today's panel discussion. I hope you all enjoyed it as much as I did. And thank you to all of you for spending your midweek lunch break with us. A recording of this panel will be available on our corporate website soon. And if you have any questions on our brand new legal drafting solution, Lexis Clause Intelligence, or would like to learn more, please feel free to get in touch. Until next time, thank you and take care.